Hello and welcome to Liberty Law Talk. I'm your host, Richard Reinsch. Liberty Law Talk is featured at the online journal Law and Liberty, which is available at lawliberty.org. Hello, today we're talking with Richard Brookhiser about his new book, John Marshall, The Man Who Made the Supreme Court. Richard Brookhiser certainly needs no introduction. He's a senior fellow of the National Review Institute and a senior editor of National Review. He's also a columnist for American History Magazine. He's the author of a number of books, including Founding Father, Rediscovering George Washington, Founder's Son, A Life of Abraham Lincoln, and Alexander Hamilton, American. Richard Brookhiser, welcome to the program.
Thanks for having me.
Hey, so this book, John Marshall, what got you interested in writing a book about John Marshall?
Well, I'll tell you the immediate stimulus. I was told to write this book by an old friend of mine, Professor Akil Amar, who's at Yale Law School. And way back when we overlapped as undergraduates at Yale, I was a senior when he was a freshman. So that's when we met in the Yale Political Union. And we've kept in touch ever since. And Akil was the man who suggested that I write my Lincoln book, and he even gave me the title. And I thought, it took me like 1 second to realize that that was a terrific idea and a terrific title. So then, when I was looking for a next book to do, Akil said, why don't you do John Marshall? So he's batting 2 for 2 so far.
All right, thinking about, so you've written a number of biographies of crucial figures in the history of the American Republic. Talk about your approach to biography writing and how it shaped your approach to evaluating the life and career of John Marshall.
Well, I try to do it simply and for the most part chronologically, and I think that's almost built into the biographical form. They're all about someone is born, he does stuff, then he dies. That's the shape of every biography. It's the shape of every life. So that's a kind of a basic point. I try to write relatively short. I think my Lincoln book was almost 100,000 words, but that's been the outer limit. There are the doorstopper books, the 800-page books, and some of them are very good, and there's a use for them if you want to have in one big volume virtually everything that can be known about this guy. That's what those books are for. But I want to write a little shorter, and that's partly because I'm interested in highlighting the public and the intellectual importance of these men. For instance, in the Marshall book, I do talk to some extent about his marriage to Polly Ambler. It's an interesting tale of courtship, and it's a sad tale of a marriage because she very soon became very depressed and ended up being a recluse. Marshall, respected her and said she was witty and she was smart. She was very well read, but she could not go out in public, could not see strangers. It was sad. Marshall's children interest me even less. He had quite a few of them, he and Polly, and among the sons there was just no one who was at his level. None of his sons at all. No disgraces, but no real achievement. I think his symbolic son was one of his Supreme Court colleagues, Associate Justice Joseph Story. There was a 24-year age difference between the two of them, so that makes for a kind of a filial relationship. And certainly from Story, he got the intellectual back and forth and responsiveness that he just didn't get at home. So although I cover the family story, the most important thing about this man is his public contribution. And maybe uniquely in my biographies, I'm also giving you big doses of what the world is like, because these cases all arise in the world. When you're a judge, and particularly Chief Justice of the Supreme Court, you're sitting at the pinnacle of a judicial system, and the cases mostly come to you on appeal. They've come up through the court system, most of them, and they all have backstories. People go to court for a reason. They want something, or they're afraid of something, and so that's why they go to court. That's why they're in court. And I want to tell those stories because that gives you a picture of American life. The steamboat case, Gibbons versus Ogden. Well, how did that arise? It's a very interesting story going back decades. Cases involving the slave trade, land speculation, on and on and on. Each one is like a short story. Each gives you a snapshot of a slice of American life, and then at the end it's presented to John Marshall, and he has to rule yay or nay.
You also situate Marshall within his relationships to other key figures from the American founding. And you start with the introduction of John Marshall as a soldier in the Revolutionary War and his connection maybe from afar to George Washington. And you sort of describe what you think he learned from Washington, how he came to admire him. And then later in life, Marshall, of course, writes a multi-volume biography of George Washington, which Liberty Fund reprints. So, maybe talk about that for a minute.
Well, I think the relationship with Washington is the defining one in his life. Possibly his relationship with his own father is equally important. He certainly admired his father, Thomas Marshall, greatly, and Thomas Marshall steered him towards the law. He wanted to raise his sons to be lawyers, and John was the eldest, and he was the one who took to it, obviously, the most. But when John Marshall is 19, he volunteers for a Virginia militia unit in 1775, and then the following year, he and his father will join the Continental Army. And Marshall will serve in it till 1781, almost the entire stretch of the war. And he fights under several battles commanded by Washington, Brandywine and Germantown in the fall of 77, Monmouth in the summer of 78, and in between he's at Valley Forge. So that is being with Washington in an eventful and somewhat desperate year. It ends well at Monmouth. It's an American draw that impresses the enemy, but it begins with the loss of the capital, Philadelphia, and then a grim winter encampment at Valley Forge. And the impression that Washington's leadership makes on Marshall is vast. Marshall thinks that this man is the rock of the revolution. He held everything together in defeat, in privation, when the troops were underpaid, underclothed, undersupplied. He was the guy who holds everything together. And it's not just a military leadership that impresses him. It's also a political leadership, because he believes that Washington correctly diagnoses the cause of the problems that the Army was facing. It was that the government that the new nation had was not adequate to perform its tasks. And so when Washington takes a leading role in pushing for a new constitution in 1787, Marshall again follows his old commander-in-chief. He serves as a delegate to the Virginia ratifying convention. This is one of the vital state ratifying conventions. The Constitution has to have 9 states to ratify before it goes into effect. But of those 9, they have to have Virginia. It's a central state. It's by far the largest. And Marshall is involved in that key fight. I would call him a kind of mid-level advocate for the Constitution at the Richmond Ratifying Convention. He gives a couple of important speeches, and one of them is about the proposed federal judiciary, where he makes a prescient defense of the court's power to review the constitutionality of laws, judicial review. And then when the Constitution goes into effect, and obviously who's going to be first president? Well, it's going to be Washington. And the two-party system appears, the first American two-party system. The Federalists on the one hand, Alexander Hamilton, John Adams, and then finally George Washington himself. Then on the other hand, the first Republican Party, Thomas Jefferson, James Madison, now the Democratic Party, but that was its name then. And Marshall becomes a Federalist. Once again, he's following George Washington's political lead in terms of America's financial policies. He agrees with Alexander Hamilton's plans. In terms of its foreign policies, he agrees with Washington's strong policy of neutrality. And then in 1798, the Federalist Party is looking pretty feeble in Virginia, and George Washington summons two young men to Mount Vernon. He's now in the role of a political operator. He tells his nephew, Bushrod Washington, and his former captain, John Marshall, you two have got to run for Congress. You've got to run for Congress as Federalists. John Marshall doesn't want to do it. He's a young lawyer. He's very successful. He's doing very well for himself. He's raising a family. He's buying property. He needs the money. But Washington just goes after him, and years later, the phrase Marshall writes is, "I yielded to his representation." Now, the story, which may be apocryphal, is that Marshall, after a few days of this, he decides, I can't keep saying no to this man I admire above every other person, so I'll just have to get up at the crack of dawn and leave. But it turned out Washington got up first and put on his old uniform. So Marshall can't say no to that. But so this is the inauguration of his public political career. He wins his congressional race, and then it's from the House of Representatives that John Adams pulls him out to be Secretary of State, and then it's from that position that he gets his nomination to be on the Supreme Court.
Besides George Washington, or the living example of George Washington, why do you think Marshall accedes to the Federalist Party, to its principles and program, as opposed to the Republican program?
Well, two reasons. The first, what we already mentioned, was the experience of the Army during the war and its privations, and the diagnosis that Marshall and many other officers made was that the Congress as it then existed was just not adequate to supplying such an effort. And so stronger measures had to be available, which meant structural change. A second reason, I think, is the foreign policy of the 1790s. The Republican Party, the Jeffersonians and Madisonians, they were very taken with the French Revolution. They really fell in love with it and did not bail until Napoleon arose. They accepted the terror. They thought, well, got to break a few eggs to make an omelet. That was really their attitude. And they thought America had an obligation as a old ally of France in the Revolution, and also as a sister republic, to be as helpful to this revolution as we possibly could. And Marshall was, just as were the Federalists, was skeptical of the revolution and very resentful of France's efforts to drag us onto its side. And there was a national sentiment that he had that just felt offended, and also felt that it would be wrong for us to intervene in this conflict, and certainly wrong to do it on the side of France. And he's really alarmed, and I think disgusted by the way that Madison, but particularly Jefferson, behave in this crisis. He thinks they're unrealistic. He thinks they're pro-French, and he thinks that they're stabbing George Washington in the back because they're not. Jefferson, particularly the Secretary of State, is not really upholding the neutrality policy. So this is the beginning of his hatred of Thomas Jefferson. They're cousins, by the way, second cousins once removed. And Jefferson hates Marshall every bit as much as Marshall hates him. And then the final thing, in 1797, there's a letter appears in the European press, and then it's reprinted over here. Jefferson wrote a friend of his, an Italian friend, who was back in Florence, last name Mazzei, And he said, I would put you in a fever if I could tell you of the men here who've been Solomons in council and Samsons in combat, but who've now had their heads shaved by the harlot England. And this struck Americans as a clear reference to George Washington. And for John Marshall, that was it. I mean, he later writes that the morals of the author of the letter to Mazzei cannot be pure. Yeah. And that's Virginia Gentleman for he is dead to me.
Yeah, that letter was new to me. And then the hatred between Marshall and Jefferson goes on for the rest of their lives.
Oh, for the rest of their lives.
Yeah. Yeah. Well, interesting part of Marshall's character, I thought, as well, you reveal is he's, other than Jefferson, he seemed to be able to get along with people who otherwise hated each other, but they all seemed to have a good opinion of Marshall, both within the Washington and Adams administrations.
Right, and it's both some Republicans he gets along with. James Monroe, he went to school with him for like a year when he was growing up and keeps pretty good relations with him. John Randolph of Roanoke, crazy John Randolph, kind of likes Marshall. He heard him argue in a Virginia case involving a counterfeiter, and he just was very impressed with the judicial quality of Marshall's mind, and he never lost that respect. But then the Federalist Party is the Federalist Party. It goes down in the blue wave of 1800. They lose the White House. They lose both houses of Congress. And like a lot of parties, when they lose, they turn on each other. And the end game of federalism, from, say, 1799 till the War of 1812, it's just a lot of bitterness and feuding. And yet Marshall manages to stay friendly with all these contending people. Washington, of course, John Adams, the man who puts him on the Supreme Court, very contentious temper. Alexander Hamilton, whom Marshall admires hugely, and even though Hamilton and Adams get into an ugly fight. And then Timothy Pickering, who's like the hardest of hardcore Federalists. He's so hardcore, he doesn't even like George Washington. He thinks Washington is kind of a wimp. But, Marshall manages to remain on good terms with all these guys. And, Pickering lives forever. He doesn't die until the 1820s. So Marshall just has this gift. And it also works on the Supreme Court. I'm sure we'll get to that. But it works with all these justices, many of whom are not from his political party, and yet he seems to charm them and persuade them.
Marshall and John Adams, Adams appoints him Secretary of State and then the Supreme Court. What do you think Adams saw in Marshall, or were it political principles, or was it also just a case of he needed competent men around him and Marshall was there?
Well, he certainly needed that. But he respects his mind. I mean, here's a younger man who clearly is intelligent and talented and hardworking. And Adams is impressed. He's pleased to have a Southern Federalist because they're not so common on the ground in the late 1790s. And Marshall gets along with him. So the match is made, and then I just have to tell the story of how Marshall gets his chief justiceship in the end game of the Adams administration, the lame duck period. John Adams has lost his rematch to Thomas Jefferson in the election of 1800, and he is looking for people to appoint to the federal judiciary, which the Federalist Party has just expanded. And, expanded for legitimate reasons to make it more efficient and more effective. But it's also a patronage bonanza for the outgoing Federalists, and they're taking advantage of it. And then Adams gets a letter from the then Chief Justice, Oliver Ellsworth, who's got health problems. He's got gout, and he just says, I got to quit. So this is a very important vacancy that has to be filled. And the man that Adams nominates is the man who was the first Chief Justice, John Jay, the great patriot who served from 1789 to 95. and then he left the court to run for governor of New York. So Adams sends his name to the Senate. The Senate approves him. And then he gets the letter from Jay saying, I'm not going to take the job. And Jay's reason is, it strikes us as kind of interesting. He says the federal judiciary lacks dignity.
Yeah.
Just not going to go back and do that. So Adams is sitting in his office in the still not finished White House. The outer walls are up, but the inside, it's kind of like a construction site, and he's there with his Secretary of State, John Marshall, and he says to Marshall, well, who shall I pick now? And Marshall says, I don't know, sir. And Adams pauses and then says, I believe I'll nominate you. So that is how the Chief Justiceship got offered to this 45-year-old Virginia politician and lawyer. It was a real last-minute thing, and the Senate confirms him. And then in March, he gives the oath of office to his cousin whom he hates, Thomas Jefferson, and he will do that in 8 more inaugural ceremonies for 4 more presidents for 34 years.
Marshall will serve well into his 70s.
Yes, right, almost to the age of 80 and into the second term of Andrew Jackson. So he's a man of the 18th century who goes right into the age of Jackson.
So it's interesting, too, just hearing that story with John Adams. I mean, it brings to mind sort of John Marshall has undervalued stock. I mean, you had a anecdotal story in the book early in John Marshall's legal career in Richmond, I think it was. A wealthy man had a legal dispute and thought of hiring John Marshall, but saw him in sort of a basic white linen shirt eating cherries out of his head and thought, I'm not going to hire that guy.
Just walking along the street.
He hired the guy in wealthy clothes, and then as the trial started the first day, he realized Marshall was the guy I should have hired.
Yes, and he goes to Marshall and he says, look, I came into Richmond with $100 to spend on my case, but I gave most of it to this other lawyer. I've only got $5 left. Will you represent me for $5? And Marshall says, fine. I mean, that's partly his good nature. He also has to know this will be a great story. This will reflect very well on me. So yeah, Marshall had, the word that comes up over and over again in descriptions of this man is simple. People describe him as simple. His manners are simple. He doesn't care how he dresses. He doesn't care how his hair looks. His wife cuts his hair for him. If she didn't, I don't know what he would have looked like. But he's just a simple, genial man. Joseph Story says, I love his laugh. I love his laugh. He likes a good drink. I have to tell this story that when he is Chief Justice, he finds that one of the customs of the Supreme Court that they've developed in their first 11 years is that when the justices deliberate after a day of hearing cases, they go back to their boarding house in Philadelphia or Washington, wherever the capital is, and then they talk about, what they have heard over dinner and afterwards. And the rule was that they could only have wine if it were raining outside. And I assume that was to cheer themselves up. So Marshall's routine that he develops with Joseph Story is he says, Brother Story, will you look out the window and tell us what the weather is? And, Story will say, well, the sky is perfectly clear. And Marshall will say, our jurisdiction is so vast that by the law of chances it must be raining somewhere. So wine was always served at the Marshall Court. So that's his geniality and his simplicity. But then back of that is this extremely powerful mind. It's a mind that's kind of slow to get going, but once it does, it's just relentless, almost implacable in the way that it organizes a case and moves through it and arranges it and comes to a decision. And the striking quotation from William Wirt, who becomes Attorney General, and he first encounters Marshall when Wirt is an advocate before the Supreme Court, and Wirt says, Marshall's mind was like the Atlantic Ocean, and everybody else's mind was ponds.
So thinking here about the Supreme Court's stature and the imprint of Marshall in raising that stature. He does so, you might say, by ensuring that the federal government is superior to state governments on disputed constitutional questions. Again, sort of relying on these clear principles. You say he would sort of sweep widely, but then find sort of a lesser principle upon which to hang his decision at times, and did this in various ways. Major cases that come to mind: Fletcher versus Peck, of course, McCulloch, the Dartmouth College case, among others, where he really establishes the federal government's preeminence and its solidity in the early republic. And I think this, is interesting, and I think you tell it well. It sort of goes back, I think, in many ways to this early experience he has as a young man, as a young soldier, and seeing the weakness of a government and wanting to ensure that, at the time, would the Union hold? Would its efficacy and competence be seen superior to the states? And I think he is looking, he is finding the ways to establish that in the Constitution.
And some of those early cases you mentioned, Fletcher and Dartmouth, they not only establish federal supremacy, they also are very important in supplying the legal armature that supports the economic and financial system that we still live under. A capitalist, contract-based system of how people deal with each other. In Fletcher versus Peck, Marshall even says that the Bill of Rights in the Constitution is Article 1, Section 10, where, among other things, it prevents the states from impairing the obligation of contract. And that's how important he thinks the right and the power to make contracts is. We think of the Bill of Rights, of course, as the first 10 amendments, and we think of freedom of speech and no establishment of religion and right to bear arms and searches and seizures, all the rest of it. But no, for John Marshall, it's that provision, Article 1, Section 10, that the states may not impair the obligation of contracts. And that's so important for him because he's also himself lived through the immediate post-war period after the Yorktown, but before the Constitution is ratified. There was a lot of lawmaking in the states, and a lot of it was very chaotic, and a lot of it had to do with forestalling or blocking the payment of debts. You don't have to pay your debt when you said you did. You could have a grace period. Or you don't have to, pay what you contracted to pay. You can, knock a percentage off. This kind of thing. And, that meant that if you made a deal, you didn't know if it was going to last, because maybe the legislature would alter this, or wipe this out. And Marshall thought this was chaotic. A phrase he used is that it affects the relations between men and men.
Yeah.
And he wants to make sure that if you sign on if you put it in black and white, you got to abide by that. And that's, on the one hand, that's punitive, but it's also liberating. It means people can plan, people can know what they're doing, and they can expect their obligations to be fulfilled. And this was, we often credit Alexander Hamilton, especially after the musical, as being kind of the intellectual who figured out the American financial and economic system, and he deserves the lion's share of the credit. But it also needed legal backstopping, and that comes from the Marshall Court in these contract clause cases, and then also there's an important commerce clause case in the 1820s, Gibbons v. Ogden.
Yeah, we're thinking about, so let me play contrarian here, is as much as so we can appreciate the establishment of the Union in Marshall's jurisprudence, the federal supremacy, particularly as it applies to commerce, the prohibition of state legislatures altering contracts, and these measures, and insisting, you think about the Gibbons versus Ogden's case. I mean, this is, you think about the way the Commerce Clause was employed after the New Deal as a way for the federal government to really regulate commerce and distort commerce versus what Marshall is insisting, no, we're supposed to be a national free market. Thinking about that, does it come at a cost? Overall, that Marshall implicitly is saying the Constitution is what the court says it is, rather than letting it be a competitive interplay between the branches of government and between the federal and state governments, and letting it be sort of liquidated through elections.
Well, of course, what Marshall would say is that the Constitution is what the people made it. You know, when you drill down to the bottom of Marshall's mind, he is a populist because he sees the Constitution as an act of supreme and original will. That's a phrase he uses in one of his decisions. And, of course, he can see it that way because he was alive when it happened, right? I mean, he saw this whole thing occurring, and he played a role in his home state in the ratifying convention there. So for him, the writing and the ratifying of the Constitution is a living memory. You know, we talk about the living Constitution, but for him, he was alive when the original Constitution was written. He has sort of living originalism, right? Because he was there at ground zero. So that's very vivid and vital to him. Now, you mentioned how the Commerce Clause has been used and perhaps abused over the years. So yeah, of course there are dangers. For Marshall, he sees the Commerce Clause as a way to have a national free market. But, you know, if there is a national market, well, maybe it can be a national less and less free market. And that's something we saw in legal decisions in the 20th century. So yes, of course there are dangers, but the dangers on the other side would be state power unchecked, and let's admit that 25 years after Marshall dies, certain states feel so powerful that they break the Union apart. You know, Marshall is the worries that Marshall has about the nation hanging together if states can go their own way are not, they're not hobgoblins. They're real worries, and we do have a very real civil war.
Yeah. Well, it's interesting, thinking about, another response to my question. Michael Grava, the George Mason law professor, great book a number of years ago, and I think came out 2012, The Upside-Down Constitution. And, he argues it's the Marshall story courts and the federal courts in that period that really could have been the only ones to ensure that provisions like the Contracts Clause or the Commerce Clause really did get enforced against the recalcitrant states, because congressmen wouldn't have done it or couldn't have done it. I mean, their interests would have cut in so many different ways. But it's a federal judiciary that can actually enforce it. And this is, Grava then, talks about how, the New Deal, in many respects, restores this, this sort of state sniping at federal government power in his own argument. But I thought that's that's an interesting part. Yeah.
Also, I think another fear that Marshall had, not just state power, but also demagogy. Which he identifies with his great enemy Jefferson. And his diagnosis of Jefferson, which I don't think is the whole truth, but I think is part of the truth, is that Jefferson, he talks a great game about, we're going to cut the government back, and of course I'll follow the lead of Congress, but he's running Congress from the White House, with hints and suggestions and through his followers and pals there. So Marshall is afraid of a willful president who wants to ride the passions of the moment, whatever they might be. And that's his diagnosis, fair or unfair, of Thomas Jefferson. But I think we have also seen that there are other presidents of whom we could say that much closer to our experience. So Marshall also is afraid of those kinds of figures as well as afraid of the states.
We're thinking also here, you talk about sort of this rearguard action that Marshall ends up fighting for a good portion of his time with the Supreme Court after the Federalists lose. and as he starts to lose justices and confronts, the Republican justices that get appointed, but he wins them over, or some of them he wins over. That's an interesting story.
Yes. His batting average is best early in his career. When he first becomes Chief Justice, the partisan balance is there are only 6 justices, so they're all 6 Federalists. And then after only 11 years, the balance is now 2 Federalists and 5 Republicans, because they've added another justice, and then 4 of them died or retired and got replaced. So that's quite a shift. One of these newcomers, Brockholst Livingston, I just kept thinking of this during the Kavanaugh hearings. Brockholst Livingston had killed a man in a duel. He'd had a duel with a Federalist, and he shot him in the groin, and the man bled out in 5 minutes. And this never came up, and even though dueling was illegal everywhere, but it was never prosecuted because there'd be jury nullification, okay? So how wild is that? But, Brockholst Livingston becomes a very dependable justice who often signs off on Marshall's opinions or writes concurrences to them. And it's, again, I just have to assume it's this combination of his geniality, of his small p politicking. He will defer to justices who are more expert in areas of law than he is. Land titles is one example. A lot of litigation involving land titles, and he generally bucked those to Justice Todd, a Republican appointee from Kentucky. Admiralty law, that was a specialty of Joseph Story, so he, tends to rely on Story in a lot of those cases. But when you give deference, you can get deference in return, which he gets. And then there's just that power of his mind. And one of his colleagues, Justice William Johnson, another Republican, the phrase he uses is, "I bent to the current."
Yeah.
And that's what so many of them do. Now, and then by the end of Marshall's life, it kind of stops working. The charm is not so effective. And instead of getting unanimous decisions, we find, 4-3 decisions, and we even find Marshall kind of, trying to jigger things so to make sure he has a majority, or even, putting some cases off so that a justice who's sick will be able to come back for the next term. Things we wouldn't imagine him having to do in the 18-teens. Yeah. But by the 1820s, certainly the early 1830s, he's losing control of his court.
Yeah, it's interesting reading your book, thinking about that. Are we better off with these majority opinions and then, maybe a dissenting opinion, or unanimous opinion? Would we be better off with separate opinions, seeing the reasoning of each justice, and sort of, so you would have a holding, or you would have, a winner, but the political debate at least could continue in maybe a more potent way without sort of this, the finality the court has spoken, this is the Constitution. I don't know, just a question in my mind.
Yeah, that's interesting, and that would be, the court could decide to do that tomorrow. Right? It's not in stone that we do it the way that Marshall began to do it. Now, would they? One reason Marshall did it is he wanted the court to have the prestige of many unanimous decisions. But of course, as you just pointed out, we're not getting a lot of those, are we? So, yeah, it's an interesting question. And then I was. I was kind of startled to realize I was really drilling down into Lincoln's reaction to Dred Scott, and of course I'd covered that in my Lincoln book, Founder's Son. But here, I was very struck by the fact that Lincoln, who was appalled by the Dred Scott decision, as was almost the whole North, he says that of course the Supreme Court does have we have to accept the court's judgment in any case on the parties to that suit. There's just no question of that. And certainly its opinion deserves great respect on every large constitutional issue it deals with. But then Lincoln makes this decision between, distinction between good decisions and bad decisions. And he's saying, a bad decision, like Dred Scott, is one that isn't unanimous. And I read that because Dred Scott was a 7-2. I mean, a six majority, and then a concurrence, and then 2 dissents. And I read that, and I thought, whoa, dude, if you're saying that decisions have to be unanimous, we're going to have to chuck a lot of very important Supreme Court decisions, including a few of Marshall's, and of course many more in later years. So yeah, that's an ongoing issue.
It's interesting as well. I think it was after McCulloch, Madison. I think it was in private correspondence that said of Marshall's reasoning about the necessary and proper clause that, well, if that was the meaning that we gave to it, I don't know why we wrote the Constitution the way we did.
Right.
Yeah.
Right.
Thinking.
Well, of course, what Marshall was doing was virtually quoting Alexander Hamilton, who of course was feuding with Madison at the time this first came up, which was, can we have a first Bank of the United States? And then McCulloch is about the second Bank of the United States, but Marshall just, goes back to Hamilton's reasoning on that point and virtually quotes it.
Yeah, but thinking so. Also, there's the well-known cases of the Marshall Court, but also thinking about Marshall on issues that concern a lot of scholars today. Marshall and his opinions as they touch the law of slavery, the federal law of slavery, and also on Indian affairs. So maybe talk about that, because that's worth thinking about.
Yes, and in those cases, Marshall relies on positive law. When he's writing about contracts, he can almost sound like a natural law theorist, especially in his dissent in Ogden v. Sanders. But when he's writing about cases involving slavery or about American Indians, he hews to the positive law, and sometimes he will glance in passing at the natural law. I mean, he says there's a case called the Antelope, which involves a slave ship that was apprehended off the American coast. This is after the slave trade has been banned, but Americans still continue to engage in it. And the question is, who do these slaves belong to? Spain and Portugal, which still are keeping up the slave trade, claim a lot of them, and that's the issue that rises to the Supreme Court. And in the beginning of his decision, Marshall says that, well, of course, it's against natural justice for people to labor without compensation for other men. But then there's a but. But we have to follow the law of nations, which allows nations to continue to practice the slave trade if they so choose. So he sort of looks at national law and then moves on. And then in his American Indian decisions, particularly the two he gives on the Cherokees, he does say at one point, why is it that just because some people from Europe came to the New World and quote discovered it, why does that give them the right to own it rather than the original inhabitants? And then he says, well, but conquest confers rights which the courts of the conquerors may not challenge. And that's almost brutal, but it's just a very realistic judgment in favor of positive law. Now, the difference between his slave cases and his Indian cases, you can see there's more sympathy in him perhaps when he's ruling on the Native American cases, particularly the Cherokees. He clearly wants to give the Cherokee Nation, which was then living in northwestern Georgia, a break. He rules against them in Cherokee Nation v. Georgia, the first Cherokee case that comes to the Supreme Court on the grounds that they can't sue as a foreign nation. He says they are a domestic dependent nation, and therefore they don't have the stature they would have if they were France or Britain coming into an American court. But he's clearly looking for a way to rule in their favor. And then the next case, Worcester v. Georgia, which is a missionary, Samuel Worcester, who's been thrown in jail by the state of Georgia. He is suing the state of Georgia. And so that's, as Marshall says, that's a proper case with proper parties. And there he says, well, Indian relations are the responsibility of the federal government. They're not the state of Georgia cannot pass whatever laws it likes with relation to the inhabitants, its Indian inhabitants within its borders. Those matters have been settled by treaties that the federal government signed with these people, and they have to prevail. So he's using the positive law in a way that would benefit the Cherokees. Now, of course, it doesn't happen because the suit, Georgia ignores it, President Jackson ignores it, and the suit is dropped finally by the two missionaries who were pursuing it. So the end result being, as we know, the Cherokees are ultimately forced to move to Oklahoma.
So prudentially, with regard to these two subjects, I mean, contentious, fraught, people on both sides obviously disagree with one another. So I think it seems to me adhering to the positive law as close as you can is the best prudential and legal move.
Mm-hmm. Right.
Yeah. Yeah.
Right. And, and I have to say of slavery, there was a big discovery that was made by a scholar, Paul Finkelman, who's kind of the Inspector Javert of slavery and the founders. I mean, he really chases down who owned how many slaves and how did he treat them. And he made the discovery that John Marshall owned over 100 slaves in the course of his life, sometimes up as many as 150. He will give, numbers of them to his own sons, but he was a very avid and acquisitive buyer both of land and of slaves to work them. And this was a revelation because every earlier biography of Marshall had said, well, he owned 10 or 12, like house servants who served him.
So that would have made him a major slave owner.
Major slave owner, yeah. And Finkelman found this. I guess he had a grad student who first started finding this material, and Finkelman looked into it, and it's all in the records, all in the records of sales and whatnot.
So thinking another relationship we just touched on, John Marshall and Andrew Jackson, towards the end of his career. Yeah.
Well,
I guess we should include Roger Taney in there.
Well, President Jefferson was his first antagonist because that's who's president through the beginning, first 8 years of Marshall's tenure. Then Andrew Jackson is the last because he's in the White House from 1828, and he's still there when Marshall dies in 1835. And the difference between the two men is that Jefferson and Jackson is that Old Hickory is just more determined. Jefferson has real intellectual disagreements with his cousin, and he can get very angry. Generally in private, but then it often burns off. Jackson gets mad and stays mad and does what he wants to do. And the Cherokee case is the great example of that. But there's also Jackson wages war on the Second Bank of the United States. He publicly questions Marshall's reasoning in the McCulloch decision. Where Jackson asserting that he, as president, also has the power to pronounce on the constitutionality of laws. And, in his opinion, the constitutionality of a bank of the United States is not a settled question. He thinks it's up for grabs, and he thinks it's unconstitutional. And so this is a full frontal challenge, and the man that he will put on the court finally, to replace Marshall when he dies is Roger Taney, who, as Attorney General, pulled the federal deposits out of the second bank. Jackson had to go through 2 Treasury secretaries who didn't want to do it, and then Taney said, "Yeah, I'll do that." So, and that keeps Taney off the court for one term of Congress. He's originally nominated by Jackson to replace Justice Gabriel Duvall, who retires, but there are enough Whigs in the Senate that they just block Taney, and then Marshall dies, and the political balance in the Senate has shifted a bit. So Taney becomes not an associate justice, but a chief justice, and he will drag on until the Lincoln administration.
Yeah, thinking Marshall, obviously, impressive career, congressman, diplomat, Secretary of State, Chief Justice. At the end of his career, what did he make of his contributions?
He feared that he'd failed. He feared that the Union would fall apart. He saw that he had been losing control of his court. He'd hoped that if Jackson were not reelected, someone like Henry Clay might allow Marshall to retire because Clay would promote Story to be Chief Justice. But that doesn't happen. And he's worried about the strength of the Union. He writes a letter the year before he dies to a Southern Unionist, and he says, whether this government is a league or a government, that's the basic question. And he's worried. He dies a worried man, and his worries come to horrible fruition 25 years later.
Well, Richard Brookhiser, thank you so much for discussing with us your new book, John Marshall, The Man Who Made the Supreme Court. Thank you so much.
Thank you.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at LibertyLawSite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.